If you're serious about understanding trademark law, you must have a general idea about how to answer these two questions. Number one, is my trademark likely to be confused with another trademark in the same space? Number two, if my trademark is likely to be confused in this way, what should I be doing about that? Hey friends, welcome back to my YouTube channel. I'm so glad you're joining me today. I'm Faith Mitten, an attorney on a mission to simplify brand protection for entrepreneurs and business owners. On this channel, you'll find tons of practical, easy to understand insights to help you get a better sense for how to protect your brand and stay on the right side of the law. And understanding the concept of trademark infringement is crucial to both of those things, protecting yourself and not stepping on anyone else's toes. But trademark infringement is a phrase that gets thrown around a lot, and you may not be familiar with what it actually means. If that's the case, I'm really glad you're watching this video because I'm going to explain it. But first, let's make sure that we lay a solid foundation by defining what a trademark is. Because the first step in determining whether trademark infringement has occurred is assessing whether the item in question can even be protected by trademark law. Trademarks provide legal protection for a business's brand identity. The things most commonly registered as trademarks include business names, taglines, and logos, but there are also non-traditional trademark registrations for things like building designs, product packaging, colors, sounds, scents, and even more. Regardless of whether the trademark you've chosen is traditional or non-traditional, the purpose of a trademark is to signal to the public who the source of a product or service is by clearly identifying that source. This way, people know exactly what company or person they are buying from or supporting. So trademarks help to keep a spotlight on your business by preventing your competitors from identifying themselves the same way. And that takes us back to the topic of this video, which is trademark infringement. Trademark infringement occurs when one brand begins using a confusingly similar trademark after another brand. Another way to say that trademarks are confusingly similar is to say that there is a likelihood of confusion between the trademarks. But this concept of confusing similarity or likelihood of confusion, while super complex, boils down to answering these two questions. Number one, do the trademarks look alike, sound alike, or have similar meanings? And number two, are the trademarks used to promote products and services that are related to each other in some way? Let's take a closer look at these two questions. First up, do the trademarks look alike, sound alike, or have similar meanings? This is a foundational issue in trademark infringement because this legal doctrine is all about confusion. Confusion is bad, of course, because it can hurt both the businesses and the customers alike. It can hurt customers because they may end up buying from the wrong company if they can't tell the difference between two brands, and they may end up getting a different or even poorer experience than they were anticipating. But it can also hurt the business because it can result in lost sales. Trademark confusion creates a lose-lose situation. That's why with trademark infringement, we're trying to determine if the trademarks are likely to cause confusion because they resemble each other in some kind of way. So what are some ways that trademarks can resemble each other in a way that's likely to cause confusion? Well, if they're identical, that's a dead giveaway that they look alike, sound alike, and may possibly have similar meanings. But there may still be confusing similarity even if there are only minor variations in appearance, sound, or meaning. Here are some examples of the types of minor variations I'm referring to. Using the plural or singular form of a word when the other trademark does the opposite, switching the order of words around, or using slightly different spellings for words. In these examples that I just mentioned, the trademarks look alike, sound alike, and may have similar meanings, but be mindful of the fact that trademarks do not need to look alike or sound alike to have similar meanings. The example I love to use for this involves the Red Bull trademark registration for energy drinks. The trademark application for Pink Cow for beverages not including energy drinks was found to be confusingly similar with the Red Bull trademark registration, even though Red Bull and Pink Cow don't look anything like each other and they don't sound the same either. but they do evoke similar meanings. They both reference a real animal that we can all identify, either a cow or a bull, but they pair that very real animal with an unusual color that is not typically associated with that animal. For this reason, people might have assumed that pink cow was somehow related to Red Bull, and that the company that owns the Red Bull trademark registration just opened a new line of products that they are selling under pink cow. And that brings us to the second big question when it comes to trademark infringement. If the trademarks look alike, sound alike, or have similar meanings, are they used to promote products or services that are related to each other in some way? Products and services are considered to be related for legal purposes if they are presented to the public in a way that might make people mistakenly believe that they come from the same source. That is legal mumbo jumbo. What does it mean in plain English? Basically, it boils down to this. Do companies usually sell these items together under the same trademark? For example, if you go into IKEA to buy a new bed frame, you're very likely to find coffee tables there too, even though bedroom furniture and living room furniture are two different things, right? And that's not unique to IKEA. Many furniture stores do the same thing, selling bedroom furniture and living room furniture in the same place. So for this reason, bed frames may be considered to be related to coffee tables. But that was easy. Let's look at a more difficult example. People who create podcasts often sell merchandise related to that podcast, like t-shirts and hats, under the same trademark that their podcast uses. So for this reason, podcasts may be considered to be related to clothing. Can you imagine not being able to use a trademark for, let's say, your line of hoodies because someone has a similar trademark already registered or is already using a trademark like that for podcasts? That is possible, as bizarre as it may seem. The reason for that is because if people are accustomed to seeing certain different things presented together by one company, when they see those things presented under trademarks that look alike, sound alike, or have similar meanings, they will assume that the same company sells all the things, rather than there being different companies that just are using similar trademarks. So if these two things are found to be true, that yes, the trademarks look alike, sound alike, and have similar meanings, and yes, the trademarks are used to promote related products and services, then there is a good chance that there is a likelihood of confusion and possibly trademark infringement by whoever was the later user of the trademark, meaning they started using and confusing a similar trademark after someone else. Importantly, trademark infringement can occur regardless of whether the later user knew of the earlier user's existence. The law of trademark infringement does not care about your motive or intent. And that's not to say that you won't get stiffer penalties if you intentionally misuse someone else's brand for your own benefit. For example, if you counterfeit someone's trademarks or try to imply some sort of connection to a brand by using a trademark that is very close to theirs. You absolutely will be penalized more harshly if you are intentionally, willfully, and knowingly committing trademark infringement. Those stiffer penalties could include having to give up any profits that you've earned from using a infringing trademark brand, in addition to having to pay damages to the brand owner whose brand you were infringing upon, as well as possibly having to cover their attorney's fees. But what I mean by the fact that trademark infringement law does not care about your intent is that there is no safe haven for people who claim they didn't mean to infringe on someone else's trademark and therefore they shouldn't be punished. Because it is every brand owner's responsibility to check whether a trademark is available before they adopt and use it. But to throw a wrench at you, just because two trademarks look alike, sound alike, and have similar meanings and are used to promote related products and services does not always mean that trademark infringement has occurred. There may be other factors that mitigate or lessen the likelihood of confusion. For example, if there's a word in the trademark that is descriptive of the products and services, there's very limited protection for that word. For example, if one restaurant calls itself Fresh Delights and another one calls itself Fresh Flavors, it may be difficult for one to claim that their brand was infringed by the other because fresh is very commonly used in the food industry to describe the quality of food. In fact, if either or both trademarks are registered with the USPTO, they would have had to disclaim the word fresh in their trademarks because of this. And a disclaimer is just a written admission that a brand owner does not have the exclusive rights to use certain words apart from their trademark. Now, I didn't talk about trademark registrations in this video because I've talked long enough already, and I wanted to focus on the topic of trademark infringement. But I do want you to know these two things in the context of trademark infringement regarding trademark registrations. Number one, federal trademark registrations, the kind that are issued by the USPTO, can provide nationwide protection for your brand so that you can shut down infringement regardless of where it occurs in the country. And number two, it is possible for unregistered trademarks to be infringed upon because certain trademark rights are created automatically when trademarks are used publicly. These are called common law trademarks, and I've talked about them in much more detail in my video entitled What is a Trademark?, which I will tag here and link to in the description. Go ahead and watch that video after this one if you want to learn more about the topic of unregistered trademarks. But if you think that your brand is being infringed upon or that you might be infringing on someone else's brand, the best thing that you can do for yourself is to get legal advice and representation from a knowledgeable trademark attorney. This summary that I provided for you here is just meant to be that, a summary of the law of trademark infringement. It is not a definitive statement of everything that you should consider, and a lot has been left unsaid. So be sure to consult a licensed attorney for help with any trademark infringement issues you may experience. And that's a wrap. If you enjoyed this video, I hope you will give it a thumbs up. Be sure to subscribe to the channel for more trademark content and turn on notifications so you never miss when I post a new video. If you have thoughts or questions to share, please drop them in the comments. I read and respond to each one personally, and I would love to hear from you. Thank you for watching, and stay tuned for the next video.